should start.
Yes.
Good morning and good evening to everyone. I think it's morning here in the States and it's in the afternoon, I believe, in Moscow. So I want to welcome everybody to our post-COVID-19 litigation discussion. And I just want to remind everyone that this is a discussion. We do not have a PowerPoint and we will not lecture. But we will make some statements at the beginning to sort of set up the discussion. This is an interactive conversation, so I'm hoping that when you have a point that you want to make, that you will make that point, and that you will join our discussion. I am Brent Clinkscale, and I live in a place called Greenville, South Carolina. Of course, South Carolina is one of the 50 states of the United States, and I am a commercial litigator in an arbitrator for the AAA and for the International Center for Dispute Resolution. I am also the chair of the South Carolina International Committee and the chair-elect of the Atlanta International Arbitration Society. And I'll be one of your hosts today, and I'm gonna let Varvara introduce herself.
Hi everybody. My name is Varvara Knutova. I'm also I'm also doing litigation, a bit of arbitration. I'm from Moscow, practicing in Russia. I'm a partner of Kveidze and Partners Law Bureau, and I'm happy to welcome all of you today in our panel. And I hope that we're going to have an interesting discussion because based on what I personally have experienced and my colleagues have experienced, the world has changed and is never going to be the same again.
Thanks, Varvara. So we'd like to start out sort of discussing 4 areas from the America jurisdiction and from the Russia or European jurisdiction. And those areas are, what is the state of litigation in both of those jurisdictions now? Are there any innovations that we've come up with so far that help us with the challenges that we may have? And what changes are good and will last, just as Varvara indicated, that things may not change back. And the 4th one is, will there develop any best practices that help the courts or the legal system get ready for the next pandemic? So those are the things that we want to discuss today. I'll start out by, my practice is commercial litigation and arbitration, and I go to state and federal court in South Carolina, and probably since late March through at least May, the courts were pretty much shut down. The courthouses had restricted access, no real public access, and everyone who at any time went in had to fully deal with the protocols of having their temperature checked, mask, social distance, and basically had to ask questions as to whether they had any family members or household that had COVID, or had any household individuals who were in the sort of front line of the fight against COVID, such as nurses, doctors, etc. So we're starting to open up just a little. And by that I mean we're starting to do hearings, of course, by either WebEx or Zoom. A number of my state court cases have had hearings on various things, such as motions, injunctions, motions to compel discovery, etc. And those have been moving along pretty well. The courts seem to have picked a specific video conference um, vendor that they want to deal with, and both the state and federal courts, and the clerks are really versed in putting together the hearings and making sure that everyone has the proper passwords, etc. One of the big things here is that, you know, our courts are public courts, so you have to provide public access. So you have a number of the courts that would have bridges, telephone bridges, for anybody who wants to join or listen to the hearing, or they may even at some point send out a link where individuals can actually get on the Zoom or WebEx in order to listen to the hearing, so that we have full access. One of the big issues, and this is a very big issue in the States now, is that we really are not selecting and or having any jury trials. There are some jurisdictions that have had maybe one or two, and they've done it with some real, very stringent protocols. For instance, they will have try to put together virtual jury selection, where sort of when you, of course, in the States, you have a big pool that you choose the juries from, and then you narrow those down based on the strikes of the attorneys. And so those jury pools, the big jury pools, can, some jurisdictions are using virtual selection, virtual selection process at the beginning, and then narrowing those down, and then potentially bringing those jurors into the courthouse based on some of the protocols I just stated, but also making sure, like, for instance, instead of having benches in the jury, the jury area, they take out all the benches and make sure that the chairs are 6 feet apart, et cetera, that you have the proper social distancing. So, but that is a big issue, and it becomes a big issue in criminal cases, because a criminal defendant, of course, under U.S. law, has certain rights and certain rights of appearance. And so a lot of judges are, of course, they're not doing any criminal trials necessarily, virtual criminal trials, because of the toughness of selecting a jury, and because the defendant has to appear. Some of them may try to do some sentencings by virtual hearings, or some other hearings with the potential defendant, but those have to be agreed to by the defendant. The defendant actually has to agree to that. So that has slowed down our process significantly. One of the things that we sort of discuss around the bar and around the other lawyers, and when I mean the bar, I mean a group of lawyers, not the actual drinking bar. But we discuss, well, will the number of cases once COVID is over, will they simply explode? And one of the reasons is that, you know, that we've had in the U.S. several bills to pass that deal with COVID, the CARES bill and several other bills, and some states, and through those bills, there's some, for instance, some states have put a moratorium on evictions. You can't evict renters if they don't pay from their apartments, etc. And then some companies are letting individuals sort of skip payments when they need to, etc. So the question is, once COVID is over, what does that mean for the legal system, and whether the legal system will explode with those type of cases that we've sort of held back and put moratoriums on in some circumstances during COVID. one of the other issues is whether we can move forward with bench trials. And a bench trial is a trial where you don't have a jury, but you have a judge who actually is not only the trier of the law, but the trier of the facts too. And they act not only as the judge, but the jury. Now, some courts are moving towards that. If the parties agree or the party waive a jury trial, then they're moving towards that because they feel like they can better handle that, of course, virtually than they can a jury, a virtual jury, or bringing a jury into the courthouse. So those are some of the issues that we are dealing with sort of in our common law system. And we're starting to, in the states, to open up. One of the real issues also is that, you know, we have 50 states. We have federal courts with 3 levels of federal courts, and then we have our state courts with also different levels. So the pandemic has, in some states, we've had significant outbreaks, even this month, and in other states, the COVID has dissipated. So those states are those courts are more ready to do certain things that may require some in-person hearings or bringing individuals into the courts in person or lawyers in person. Whereas the areas where there have been outbreaks, they are not necessarily ready to do that now. So we have different areas in our jurisdictions that are moving faster than others, and some are even simply just shut down. So that sort of gives you a brief sort of explanation of the challenges we're dealing with in the states and in our common law system. And Varvara is going to talk about some challenges that they're dealing with in Russia and the European system.
Thank you very much, Brent, for interesting report and interesting update. Can you hear me well?
Yes, very well.
Okay, very good. So apparently COVID-19 affected the Russian legal system and changed it a lot. Of course, our courts were closed as well, except for super urgent cases in criminal cases when the decision needs to be taken whether to put the person into prison or not urgently, the detention. So for the rest of the cases, the courts were closed, so it was all dead. Then courts started to open. It was very much restricted. So not many people were allowed in one room. For example, only 5 people in one room at commercial court. Can you imagine? So it's a judge, a secretary, and only 3 persons from outside, meaning the defendant, the claimant, and a third party. You choose the way you want, but only 3 persons. Can you imagine? But normally, in a big case, you can have much more persons involved. And there is also a problem when you have, for example, 2 lawyers, or when you have a client and a lawyer, and you want both to be in the room and in one time. And it was a problem. And the courts didn't want to treat it as a violation of rights, violation of right to access to jurisprudence. So it was really a problem. And on bankruptcy cases, it was a disaster, because in bankruptcy you have many participants. And for example, I had a case where the judge was so kind to book a a big hall for the presidium of the court, so that all of us could be there. It was so beautiful, like in a movie, you know, like in a Hollywood movie, when all the lawyers were sitting in nice chairs, and it was so great and beautiful. But only in one case. Normally, it is a problem. So the judges are suspending cases because they cannot manage people all together in one room. So it's problem number one, and it's still existing because certain limitations still work, and you really need to think about the logistics. For example, if there is only one of you who is allowed to the room, who it will be? You, the client, the in-house lawyer of the client who is allowed to speak, or it should be only one lawyer, and how are you going to change participants? It's the problem. On good things, our software is developing software to support commercial litigation. So now it is not longer a problem to have a court hearing in the Far East, which is, I would say, more convenient than not convenient. If, for example, you have a preliminary hearing somewhere very far away, you do not need to take a plane and to fly for 9 hours. 9 hours, can you imagine, to have a 20-minute preliminary session? It used to be the case. It used to be the case when lawyers had to do so. Now it is not like that. Moreover, now you can apply for online access to court files. It is still not very well structured, so there is no special person who will sort out all files, so it won't be that beautiful. You need someone, a trainee, to help you to sort it out, but still it is possible. So you file a motion, they open it to you in Access, and you can see the case files, which is beautiful, because to send someone even to the Euros, it was a problem, or to find a local lawyer to see the files. So it is developing every day. So they're working on the software. It's now working faster. The access is better. The assistants to the judges are really trying to help and to manage the situation. This is the advantage. The disadvantage is that the court hearing can face technical difficulties, which not necessarily will lead to cancellation or reschedule of the hearing. So, for example, you face a problem that there is no sound. So they do not hear you. You are speaking, but the judges do not hear you. Possible options from real life. They're suggesting you, why don't you call us on WhatsApp? It is a real case of my colleague who had a court hearing at cassation court level. So there was video, but no normal voice connection. So he dialed the secretary via WhatsApp. So they used speakerphone, and there was a hearing via WhatsApp. Also, we know that in Euros courts, there were hearings in WhatsApp when the software was not working properly. On the one hand, it's good, but it's not really good when somebody decides to switch you off. It's one of the biggest problems, by the way. For example, now a moderator can switch your sound on and switch your sound off when you start the discussion. It's good when it's a conference, but when it's a court hearing and the judge is saying, okay, I do not allow to use, you finish, for example. In normal world, you can say, hold on, sorry, I still, for example, want to exercise my right and finalize my speech. It is, in the normal world, of course, you don't have a fight with the judge, but still you may insist in the reality. But when you are online, you cannot insist because they just switch off the speaker, and whatever you say, they do not hear it. And we still do not have court practice on challenging such things and on challenging judgments and awards based on these violations. And what is violations. Still, there is no court jurisprudence on this issue. This needs to be kept in mind, and that's why, if it is technically possible, and the hearing is really important, we still try to be present, because when you're present, you still have chances to interfere into the process more actively. In our jurisdiction and our legal system, as you may know, we do not have a problem of interrogation of witnesses. It is still not that common. In very rare case in civil courts, you would face the necessity to summon a witness. Normally, these are all kind of family disputes, maybe not really big cases, I would say. So normally commercial cases are decided at the state courts based on the available documents. So here we do not have such a problem. But if we move to the problem of documents and evidence, the situation now changed in a very funny way. Russian litigation used to be, Russian litigation tradition used to be very much orthodox in terms of what is sustainable, good and solid, what is good solid evidence. Normally, paper evidence with seals, stamps, the more stamps the better, would be treated as a good evidence, which a party had to provide to win a case. Now the situation is changing. I'm not now getting into the legal basis, which allows parties to bring emails as evidence. But now, when we come to online turnover of documents installed also in companies, email exchanges, emails become evidence. More and more, email correspondence becomes evidence. I think that it will be developing, and the role of email correspondence will grow significantly. And several years ago, if you ask someone from Russia to disclose email correspondence, you would most likely face a reaction, why should I? There is no sense to this. Well, I do not have to. Or, for example, oh, I want to show an email which proves my case, and the lawyer would say, you know, the court may take it into consideration, but most likely it won't be that decisive. So, in current post-COVID reality, I'm sure, as long as we are going online, the role of email correspondence evidence will grow, and this needs to be taken into consideration. So I was also thinking about such a problem as servers. Russia is also very much formal in the service approach. Russia is part of the Hague Convention, as you know, and we really insist that all procedures are complied with, and as usually everything on paper. In the modern world, when everything is becoming online, I believe that we are going to face the new reality when countries, at least most of the civilized world, decides that certain secured internet channels can be used for cross-border service. For example, like they use it in, you know, in Russian Post. You can send a letter by internet. You download a letter, as long as you do not, it's not super secret. So you are ready to disclose it to a post officer, but they assume the responsibility not to disclose it to any third parties. So you download the letter, for example, the notification or the course notification, and they print it out in another end of the country very quickly, and they make real on-hand service, but the letter is delivered very quickly. It's just, you know, one click. the world is changing, and I'm sure that the service will become more swift, and it will be much more difficult for parties to evade from such service. So these are actually our developments in Russia. I have an inquiry from colleague. Sorry if I pronounced the name not correctly. Iris Kveidze, who wanted to comment on the developments in Nigeria jurisdiction.
Yes.
Okay,
Oh.
shall we?
Can she unmute?
I'm suggesting, I'm asking her.
Yeah, I'm unmuted. Can you hear me?
Yes, we can
Hello?
hear you. Yes,
Hello.
we can hear.
Cool. All right. So, yeah. So, like, I'm a Nigerian lawyer. I'm actually American and also Nigerian, and I'm a litigator and an investment lawyer in Nigeria. I work for an IPA, a number state investment promotion agency. It's a subnational investment promotion, but we dibble and dabble in litigation once in a while. Because of COVID has put us in a very interesting, let's say, position in the country. Our justice system is purely bureaucratic. Everything is done physical. But because of this COVID, we kind of like had to move towards having like virtual hearings and e-registries and all that. And that is kind of hard coming from the fact that majority of lawyers are, how would I say this in the most nicest way? They are mostly litigators in the country. Most lawyers are not so keen on anything electronic, anything that has to give them some sort of like improvement in terms of doing anything online. And they're quite skeptical of such innovative mechanisms. So with COVID, it kind of like propelled us into like a very aggressive way, because they're still, pessimistic about the whole COVID. And there is a little bit of, is COVID even real in Africa? Because, people move around, no masks and all that. And the lockdown kind of like made everything even much harder, because majority of Nigerians are daily earners. I believe you guys are aware of this.
Yes.
Okay, wonderful. So it's kind of hard, and also before COVID, most of the courts have gone into vacation. So there's only like vacation judges who have a particular time they have to sit, and there's only like 5 people who are allowed in court. That is the judge, the registrar, and the 2 parties. And we don't have a jury system in Nigeria. We are purely, the judge is the judge would adjudicate on the matter. He doesn't have any assistance from a jury, just the evidence, and then he makes the decision. So in Nigeria, our case is quite, I think, because we are a third world country, but we're inching towards a lot of development. There has been a lot of development in this sense, especially the judiciary, in regards to our National Judiciary Commission, who has really put like a plan even before COVID in trying to automate some courts. So in our courts, we have this system where you have the magistrate court, then you have the customary courts, which is mostly for like customary disputes, and Sharia courts, where if anything that has to do with Islam, those are the lower courts. Then you now have the courts of record, which is the high court. We have the federal high court, which is for federal cases. And then we also have another court for just investment. Then we now have the Court of Appeal and then the Supreme Court. So the levels of appeal all have imbibed this whole only five people in court. And mind you, this is just vacation judges. And there's like an influx of cases on a daily basis in terms of land disputes, mostly commercial disputes because of COVID. And, you know, majority of a lot of businesses in Nigeria have suffered and they're taking their recourse to court. So in that instance, our court is now muddled with so many cases. And there's this conversation we're having in our country as to making specialized courts for specialized disputes. For example, we have like fast track courts, but those fast track courts, they can't be used that much because of there's only 5 people allowed in court. So even with the fast track court and the multi-door court, we still have a restriction on the amount of people who can attend court sessions. And our court sessions are public as any other jurisdiction. But the whole thing about the whole COVID has really pushed us into a situation where most Nigerians have no choice but to embrace this, you know, innovative, you know, how will I say this? Technology. Most Africans are not that technology savvy. Though they have a phone, they can operate using WhatsApp. They can't just fathom, like, for example, in my state, we had a case where it was on WhatsApp. So the lawyers were like really, really confused as to why should they use WhatsApp as opposed to not going to court. So the option, the judge obviously was a friend of mine, and he was, you know, telling the parties that this is the new age. We have to get on the bus, you know, and it's been quite interesting to see how Nigerian lawyers are moving towards using technology under this pandemic. And it actually has helped us in a bit in making people see that it can be used for good and not for evil. Because I believe you guys all have an idea of, oh, Nigerians are scammers. And a lot of people say that, which is a lie. We are not scammers. We do have a lot of people who are professionals and do things the right way, but we are always in the spotlight.
That's very interesting, and
can you hear me?
it's a great. Yes, we can hear you. Can you hear us?
Oh, clearly, I can hear you. COVID has really helped us, especially with the judiciary and with the bar as well. We have the Nigerian Bar Association has helped in regards to technology. For young lawyers in particular, there was an initiative that kind of like helped all young lawyers under the 10 years at the bar. They gave them free online resources. There's like a platform we use to like find our cases, like a database, which we use in Nigeria called Law Pavilion, and it was a free subscription. And these things are like slowly coming in, you know, so like you can see that in our jurisdiction, well, you won't see it, but someone that is in this jurisdiction will see that technology is taking up that space of becoming a provider to the judiciary as opposed to being their worst enemy. So that's like my contribution to the whole conversation.
Well, that's great information, and it's a great contrast, I think, to some of the things that we're dealing with in the American system. I like your comment about how it's moving Nigeria forward, because I do believe in some respects that COVID kind of pushes us to where we need to be, especially with technology. Varvara mentioned the cost of doing things, the cost of travel when you're going just for a 20-minute hearing. I think those are the type things, the technology when you're doing hearings, technology for depositions. I think those are the things that COVID has pushed us to that will now stay around because they're efficient. They take away the big cost element, and a lot of lawyers during the COVID era would probably rather have the individual on video, so without a mask, as opposed to in person with a mask, because they can see how they react to certain questions, and they can see their demeanor. In the American system, looking at, observing a witness demeanor observing how a witness reacts to a certain question or something that the lawyer says is very important in judging the credibility of the witness and whether the witness is really sort of in some aspects telling the truth. So in some areas, the technology has helped with not only the access to the courts, because you can get more people involved during the COVID era if you have them on the video, and then in some respects, individuals are more willing to be involved as opposed to coming down to the courtroom. There's an interesting study by the state conference of courts here, where they have more participation now in domestic cases, and by that I mean marital disputes and custody disputes from witnesses and individuals. They have more participation, whereas before, when individuals had to be there in person, sometimes they would not show up. So now they're more readily able to show up, and they can, whether they can do it at a private place on their job or at home. There are some aspects of the video and of the WebEx and Zoom that are really providing greater access to courts, greater access by individuals to the courts and to certain hearings. Do we have any more comments about that subject? One of the things you mentioned too, Varvara, was how the software is developing in Russia in order to meet the needs of the hearings. And that's one thing that is happening here from the standpoint that some courts, I believe like the Arizona state courts, are really focusing on how they might, the things that they need in a software. For instance, if you're going to do a trial or some type of very important hearing, you may need a room where the attorney can go with their client in order to discuss some attorney-client privileged information or private information, where they can't do it on sort of the bigger Zoom or the bigger WebEx. So having those certain rooms where they can do that I think is becoming even more important. And then in trials, a lot of times, and maybe sometimes in hearings when there is a public hearing, the judge will have a sidebar. He'll want the lawyers, or she will want the lawyers to come up to the judge's podium and actually have a conversation with them that's pretty much a private conversation, maybe about the law about a witness, where you can't necessarily do that in some of the software that the courts are using. So they're looking at how this aspect of COVID can better the software as we progress.
It's a very good point, Brent, in fact. By the way, many lawyers from different jurisdictions, even common law jurisdictions, really see that the number of claims decreased significantly, not only because the courts were closed, but because in fact you could file a claim. There would be no progress, but in fact you could do this, for example, online, because the online system was installed very quickly. Also you can send it by post, for example. Yes, it would wait until a certain period of time when the court started to work and to process it, but still the claim would have considered as filed. which was important for from the statute of limitations viewpoint. But the number of claims decreased significantly because the clients were deprived of the possibility to talk to their lawyers in person. Because in fact, you do not trust sometimes even Telegram or FaceTime, which are considered, or Signal, which are considered to be very secure sources of information. And you do not want your attorney-to-client conversation to pop up somewhere on YouTube, for example. It is really a case. You're very right that software must allow such possibility for the clients to talk to their attorneys privately, especially when they are located in different places. But honestly speaking, I think that still there is no chance to substitute it fully. For example, in criminal cases, we have this. It's really very much disappointing because in accordance with the law, the accused person always has the right to talk to a lawyer. But in reality, your client, for example, is sitting in jail and is having a video conference from a special room, and you are at court and you do not have access to your client. So it's good if you can split. For example, one lawyer is with the client in prison and you are at court, but still you cannot talk to each other.
Right.
And it is a real violation, which is so far it is ignored, I would say so, honestly.
Well, one of the things here is having a full view of the witness, the lawyers, especially if you're actually on the video cross-examining a witness. You want to have a full view of them because they're not necessarily supposed to have notes with them or any type of thing that helps them necessarily with the answer unless you show them a document. So one of the issues here is whether you have a video capability of just making sure that you have a full view of the witness, making sure that when you're doing some hearings that the witness is the only person in the room, unless the lawyer's there with them, but the lawyer may be somewhere else on the video, making sure they're the only individual in the room also, and they don't have any type of third-party assistant in answering questions. That's easy to do when you're in a courtroom, but not so easy to do to confirm necessarily when that witness is on a video and they're in some remote place.
I guess we have a colleague, Anna Karen, who wanted to comment.
Okay.
Yes, if I may. Good afternoon, everybody.
Good afternoon.
I would like to offer a slightly different angle by way of contribution to this discussion. I'm a simultaneous court interpreter, legal interpreter based in UK. And with regards to the sort of positive sides of COVID, in terms of development of software and other facilities to assist the litigation or arbitration process, what we notice, people from my guild, is rapid development of simultaneous interpreting platforms, remote simultaneous interpreting platforms, which were in the embryonic state some 12 months ago. But as of March, there are a lot of companies now quickly putting on the market different solutions for remote simultaneous interpreting. Having said that, there isn't so far an ideal platform that everybody in my community would agree replaces the physical booth, but hopefully we will get there. One of the difficulties we face working as interpreters, working remotely, is we can't actually communicate with each other. When we sit in the booth, we share a lot of non-verbal communication, we help each other, we look up dates, figures, and assist each other throughout the process. Even when we swap and it's our 20 minutes off, we're still on duty. Doing this remotely is much more difficult because you have to follow so many things at once on your screen, your live note, your documents. You want to see the face of the counsel, face of the witness, and communicate with your colleagues. So the cognitive load obviously is much higher than it is in real live hearings. So we're all busily working to adjust to this reality, and we're all hoping that there will be solutions in the future, in the nearest future, that will make our life easier and your life easier as well as our clients. Thank you.
Excellent comments. One of the comments that you made, Varvara, about the filings going down during COVID is an occurrence here also, because a number of courts were actually closed, even though you can file online. That sort of was a deterrent to people filing, because they couldn't necessarily have the ability to kind of talk to their lawyers about certain things, and also the lawyers had limited ability to talk to them. But one issue that where that really matters is when you have either pro se plaintiffs or pro se defendants, meaning individuals who are not represented by lawyers, who actually are taking on their own case. But they may not know the ins and outs of electronic filing, and they may simply, when they file their case or when they respond to a case, go down to the courthouse and just file it at the courthouse, which they could not do. So that was one of the issues that the court had to deal with. Here, the court has sent out some directives as to having a mail-in more directive for pro se plaintiffs and pro se defendants, but they also have a drop box where they can simply drop either their response or their complaint off. And you don't get really, well, I think you're doing prisoner cases, but maybe you don't really have a lot of, you don't really have a lot of pro se plaintiffs or defendants in federal court necessarily, but you do have a lot of them in the state courts. So that's an issue that they have to make sure they are paying attention to, because of our access to justice principles, and the idea with that we want to have everybody be represented or have the ability to represent themselves fairly in the court system. So any last minute comments? I think we've got 1 minute left. Is that correct? Well, Varvara and I want to thank everybody for participating, and thank those who came in to discuss their specific issues. Those added a lot of value to our conversation, and I think gave all of our participants sort of a perspective from different areas. Varvara, you want to say anything at the end?
Thank you, everybody. Thank you for your attention, and I'm sure that, of course, nothing can substitute real meeting and a real interaction. But anyway, we are very grateful for your attention, and I'm sure that we're going to discuss this problem more and more, because, as we already said, life will never be the same again.
Thank you, everyone.
Thank you. Bye.
Thank you. Bye-bye.
Thank you. Bye.
Thank you, Brent. Bye.
Thank you very much. I thought that went well.
It did. Have a good day. Bye.
You too.